I'm Andy Fields. I'm an attorney at the Jeannie Harrison Law Firm and chair of the BHBA's Employment Law section. I am delighted to introduce our speakers, Justin Marquez and Allison Ekstrom. Allison Ekstrom is a mediator with signature resolution. Allison brings over 2 decades of experience in employment and wage and hour litigation. With a proven track record of resolving complex disputes, she has represented clients across the retail, financial services, technology, transportation, aerospace, pharmaceuticals, property management, and hospitality industries. Allison has litigated more than 250 class and representative actions in federal and state courts, skillfully navigating claims involving meal and rest breaks, regular rate of pay, wage statement compliance, rounding, off-the-clock work, expense reimbursements, and employee misclassification, among others. Justin Marquez brings over 15 years of distinguished experience in complex litigation to signature resolution. He has successfully litigated class actions and individual employment cases at the highest levels, including the Ninth Circuit Court of Appeals, the California Court of Appeals, and the federal district courts nationwide. A recognized leader in class action litigation, Justin has a proven track record of securing landmark victories in wage and hour, consumer protection, and data breach cases. And now let's get started.
Thank you, Andy, and thank you everyone for joining us today. I hope that our presentation and our diverse backgrounds in the wage and hour space offers you some helpful tips in mediating your next class or PAGA case. Justin is going to start off today's presentation talking about the best time to mediate a class and PAGA lawsuit, the factors to consider in selecting a class PAGA mediator, and how to best prepare for mediation. Then I'm going to spend some time talking about the scope of class and PAGA mediations, and in particular, how to ensure that the release that you negotiate as part of your settlement effectively bars future litigation of the same claims and accurately reflects the parties' agreements. Finally, we'll conclude with some post-mediation considerations and take your questions. And of course, if you have any questions along the way, feel free to drop them in the Q&A box and we can engage a discussion. Now I'd like to turn it over to Justin.
Thank you, Allison. Hi, everyone. Thank you for joining us today. I'm going to get started by talking about when are the parties ready to mediate. A case can be ripe for mediation at 3 different stages. Early litigation, and what I mean by that is shortly after a complaint is filed and the parties complete an initial status conference. It makes sense because it's cost efficient for both sides. Let's face it, not every case is worth litigating towards class certification. Even if a plaintiff wins class cert, it's not clear that a defendant can afford to pay full liability, especially when we're, talking about millions of dollars at stake. Defendant might also want to get rid of a case early if liability is clear, such as a rounding or a facially unlawful meal or rest break policy. And money saved in litigation can be spent for settlement. In order for early mediation to be effective, it requires the willingness to exchange data and documents, even the bad stuff. So we're talking about time and payroll data, policies and practices during the relevant statutory period. In my experience, the biggest hurdle towards early mediation is the presence of an arbitration clause. Most defendants assume that an arbitration clause will be upheld. For you plaintiffs' attorneys out there, have you ever met a defense counsel that didn't like the arbitration agreement? Of course not. They probably drafted it. But we did fight those when I was litigating. I've had cases resolved on a class basis after we successfully challenged contract formation, such as the authenticity of an e-signature. The upside is obviously huge because it opens up a class settlement instead of an individual or PAGA-only settlement. The next stage is where there's been some written discovery, some depositions, and maybe even a fully briefed class certification motion. In these cases, you have to develop the evidence to see what are the real risk and value of the case. If the employer is not going to pony up big dollars early, it's worth it to do the work. And when you have cases that are more fully litigated, you have a better sense of the strengths and weaknesses of the case. You know, you're likely to have taken depositions, HR depots, PMKs, written discovery. You know, you have an expert report ready typically. You know, some dispositive motions or rulings might have narrowed the scope of the claims. And, you know, after the litigation work has been completed and you're facing a class certification motion or you filed one, class certification is not a slam dunk for either side. So the parties want to mediate to avoid the risk of an adverse ruling. In my experience, litigation doesn't really help in driving the settlement value down. Usually plaintiffs want more out of the case in order to get a return for the work they put in. And, you know, once a cert motion has been filed, you're already in the mindset of being willing to roll the dice. So, you know, my preference is early mediation, especially because it makes sense, you know, cost-wise. Now, the final stage is where there's been a ruling on class certification or a trial on the merits. You know, at this point, the court has already made a decision and picked a winner and a loser. You know, one side is up against the wall, but even then it makes sense to mediate a case. There's always the risk of decertification. It could happen anytime. I had a case against Bank of America that was litigated for 5 years. We did summary judgment. I won class certification. I beat a 23F petition for permission to appeal in the Ninth Circuit. Yet a year later, the case was decertified. So when that does happen, it's the worst feeling in the world for a plaintiff attorney. But in contrast, you know, defense is jumping up and down because they've snatched victory from the jaws of defeat. And, you know, appeals can take forever. I've worked on cases where that were in appeals for 10 years. Harris versus Liberty Mutual, I worked on that. That was in the Supreme Court and California Court of Appeals for 10 years. ABM Industries overtime cases, that was in the Court of Appeal for 5 years. So, you know, that is a big risk. You know, that consumes a lot of time. You know, you might be better off selling the case. So, Allison, do you have any take on this slide?
No, I think you covered most of it. Thank you.
Okay, let's move on. Do I see any questions? No questions. Okay. Okay, so you've decided to mediate. How do you choose the right mediator? Every mediator has a different style. You know, some are more evaluated by, you know, what I mean by evaluative is that they're opinionated. They're going to tell you what they think about your case and the likely outcomes if the case proceeds towards litigation. I think in order for this approach to be effective, the mediator has to be wage and hour savvy. It's got to be credible. On the other hand, you have facilitative mediators who are less opinionated, more neutral. You know, the approach is to help the parties find a path to resolution more organically. You know, that could be helpful when creative solutions will be needed for settlement, you know, and when counsel for the parties drive the negotiations. I don't think it's the best approach for these cases. I typically prefer someone who's evaluative and, you know, gets to the point and, you know, tells me the strengths and weaknesses of the case. And there's also the data-driven mediator who's very comfortable with the numbers. That person is good with claims that can be proven based on the record, such as meal period claims, regular rates. But usually that type is less effective with claims that rely on anecdotal evidence, like off the clock and rest breaks. You know, I wouldn't necessarily bring a bag check case before a mediator that prefers having data, having records to, you know, really hammer home liability. And there's also the corporate savvy mediator, someone who's good at communicating risk to a corporate representative, who's able to get them to come to terms with liability. You know, that's useful when an employer is not based in California, who's unfamiliar with how it's done here, especially with these complex wage and hour laws. So, and the high penalties involved with PAGA. So having someone who's more corporate savvy can, really carry weight if, as far as messaging goes, if it's being delivered with someone who has a proven track record in this area and can get through with difficult clients on the defense side. Let's move on to the next slide. Let's talk about mediation preparedness. Overall, it's important for everyone to be on the same page about the scope of the claims. Ask yourself, is the complaint specific enough to put the employer on notice about the claims in dispute? Most complaints are pretty generic. Same with the PAGA letter. So, you want to avoid surprises in a mediation. If you're a plaintiff attorney who spotted a new claim that's not specifically spelled out in the complaint, you might want to pick up the phone and tell defense counsel about it before the mediation. And another thing to consider is the impact of other pending overlapping lawsuits. It's important for both sides to do their due diligence and understand whether other lawsuits have an effect on the mediation, because the goal of mediation should be finality. You might not get that if there are other plaintiff firms involved in the case that might cause trouble with an objection down the line. So sometimes a global mediation might make sense. And as far as preparedness goes, these cases are typically data-driven. Timekeeping and payroll records are key. Getting them is important, and getting them on time is extremely important. In my experience, the number one reason why mediations get delayed or rescheduled is because of issues with getting the data on time so your expert can analyze it. It already takes several months to book a good mediator, so rescheduling means, additional delay that you want to avoid typically. So to avoid this issue, the best practice is to have an early conversation about what type of format the data is in, paper or electronic. It's going to be more time consuming to pull paper records, which means you have to also talk about sampling. And in my experience, it's also hard to get the electronic records on time. Typically, I ask that they be produced a month before mediation, but more often than not, they're usually produced a week before. And that doesn't help anyone when that happens. So you should consider scheduling regular calls to discuss the progress of the data. Have calls every 2 weeks with counsel to discuss what's going on. Are you going to get this to me on time? That also helps build rapport with opposing counsel. So I found that approach, pretty effective in my cases, but still, I still get it pretty late, but, it's worth trying. But if you exchange data the last minute, it's easier to be vulnerable to surprises. For example, plaintiff might spot a regular rate claim by looking at the data, but it's not in the complaint. There's one case I resolved where there's like this big makeup pay claim. It was a 7-figure claim that we only discovered after looking at the data. So there's more to the data than just work weeks. You have to really analyze it carefully, hire an expert, make sure you have time with it to go through the different permutations. Another question is whether you're getting a full data set or a sample. I recommend producing the full data set if it's all electronic. Of course, it's not gonna be realistic if it's paper, but electronic should be fine. It often takes longer to get a sample because there's usually some back and forth about the appropriate sample size, and the data has to be filtered. All that takes time. A sample can also cause issues down the line. I've had cases where the defendant overestimated the work week count by 30%. When that happens, defendants are just giving money away. When You know, it's a different case if the work week count is 30% lower. I've also had cases where the work week count was underestimated and resulting in the escalator clause kicking in. I mean, these problems can all be avoided if the full data set is provided. And it's also important to note that courts are also scrutinizing the sample size and whether it supports a Couloir analysis. If the sample is too small, your settlement might not get approved. This is a big issue in San Francisco. I've seen this happen in Orange County, LA. Another topic to talk about in preparing for a mediation is whether you should exchange briefs. I wonder if this is controversial and how many people actually do it. When I was litigating these cases, I didn't like exchanging briefs. You know, I thought that I didn't learn anything from defendant's brief, and I was worried that if the case didn't settle, defendant might use my brief to prepare for a deposition. So I didn't really see that much upside when I was litigating these cases. But now as a mediator, I see the value in sharing briefs because it helps educate the other side on how you see the claims, and it's a way to demonstrate your competency. All that is helpful towards settlement, I feel. Let's also talk about what should you put in your mediation brief. As a mediator, I like to see the expert report. You know, I've been doing this a long time. I'm very comfortable with numbers and spreadsheets. I want to see the actual report because it usually has more details than a summary of findings in a mediation brief. I also want to see corroborating payroll and time records that back up your arguments. If you have a regular rate claim, show me the records that back it up. Usually if, you know, defendant insists that they're doing a true up on a regular rate claim, you know, show me instances where they're wrong, because it's hard to explain away something when there's an actual paper record of the problem. So, you know, exhibits with actual examples are very helpful. I also want to know about the judge in your case. I've litigated over 1,000 of these cases all across California. Most likely, I've been before your judge and I know how that judge is going to rule. You know, there are even some judges I've litigated class certification against. So I find that helpful as well. But sometimes I don't see the judge's name being mentioned, the venue even. So that's frustrating. Allison, what's your take on, you know, tips for mediation preparedness?
I think hiring an expert is critical. I'm going to touch on this a little bit, but you can often find on both sides, the plaintiff identifies claims that, you know, they didn't know they had. Employers may identify claims that they don't necessarily want to bring to light, but want a release for it. I definitely think there's value, even though there's expense associated with in getting an expert. I tend to agree. There are pluses and minuses to sharing briefs. I think once there's been a lot of litigation, if you're doing a mediation, maybe post certification or right before certification, there may be more value to exchanging the briefs. Whereas if you're doing an early mediation where there's been a stay of the litigation, and the parties are going to see if it's there's a path to settlement, but they may be miles apart in terms of settlement value, that they may want to keep the briefs confidential so they're not tipping their hat too much on what their defense is or their strong claims are.
Yeah, great points. Great points. You know, we want to keep this, we want to try to keep this collaborative and interactive. Looking at questions, there aren't any. Let's move on to the next slide then. Hopefully there'll be more questions at the end as we talk about these issues that we all face, you know, very commonly. Okay, moving on. Financial disclosures and considerations. So many mediations stall out because of financial inability to pay. You know, it's very frustrating to see that, especially if you waited several months to get to mediation. And, you know, the thinking is when I experience that is why didn't they tell me before? You know, why maybe this mediation could have even be avoided if there are serious financial issues that they disclosed before. And when you're put in that situation, often you have to schedule another mediation just to get the financials. When that happens, feels like mediation's a waste of time. So bringing up financial issues at the last minute on the day of mediation is for sure going to kill any prospect of settling that day. So the best practice, I believe, is to bring up financial issues early so a party doesn't get blindsided. I get it though. Sometimes it's a surprise to defense as well. And by the time they find out, it's too late to reschedule without losing on the mediation fee. It's also a tough spot to be in. But at the very least, I ask you, defense counsel, to, bring some documents at the mediation that helps with transparency. I'm talking about tax records, profit and loss statements, lines of credit, etc. The more you're willing to disclose at the mediation, it adds to credibility. Like, okay, your client is really broke. I get it. Okay, you're showing me the documents. This has happened to me so much that I've had a forensic accountant on call. She's I didn't even have to tell her that I'm meeting that day, but she's the type to if I had a meeting case and there's like financial issue, I just send her an email. She's going to work on it and give me an answer that day. If you want her name, I could give it to you. Just shoot me an email. That's fine. She's worked with defendants as well. She's great. I've worked with her for a number of years now. And so, it happens so much that I have that person on call, and it's worked out for me. I've been able to get cases resolved that way, because I can't really understand these financial records. Usually it's over my head. So, let's see what's the next. I think I'm going to kick it over to Allison next to discuss the scope of mediation. But do you have any thoughts on that slide before we turn it over to you, Allison?
No, I think you covered it. So let's talk. Now everybody's agreed to go to a mediation. And the question is, what's the mediation going to really be about? It sounds like an easy question. Let me get to the slide. But oftentimes a mediation can morph into a completely different day than the parties otherwise would have expected. And we've touched on some of this, but want to emphasize that, you can come to mediation and of course, everybody's prepared for the claims that are alleged in the complaint or in the PAGA letter. But it's not uncommon for claims to be raised for the first time at mediation by the plaintiff, right? As we mentioned, they look at the time records, they identify a rounding claim that they otherwise didn't see when they were preparing the complaint, and that becomes the center of the day. And conversely, the employers can come up with issues that they identify too. It might be a wage statement that's non-compliant that they didn't realize, during the statutory period, that maybe it's corrected now, but they know that there's some vulnerability there. So they want that to be part of the day. And as the mediator, I try to do pre-mediation calls with both sides. And I really encourage the parties to, at a minimum, give the mediator a heads up that there are going to be some additional claims, theories of liability that they want to address during the mediation. So at least we have a heads up to that. Also, the effect of a prior, this is a very common one. We go to mediation and then the employer raises the fact that there's a prior class or PAGA settlement that either cuts off the time frame, could potentially bar the litigation entirely. And so that's, the parties need to be on the same page in terms of what the mediation is about. And so the last topic about the effect of prior agreements raises a larger issue that I'm going to spend quite a bit of time on today, because hopefully you go to mediation and you reach an agreement to settle the case. And obviously there's a release of claims that's going to be the main result of the case in exchange for the monetary settlement. And so understanding the breadth of a class and a PAGA class or PAGA release is critical to making sure that, you know, both sides are getting the benefit of their bargain, I'd like to say. And as many of you know that do these types of cases, you know, there's limits on what you can release as part of a class or PAGA settlement. Obviously, for example, you can't have settlement class members or aggrieved employees be bound by a 1542 release, right? There's limitations. And the case law has evolved over the years in terms of what they're really bound to and what they're really releasing. One of the seminal cases that talked about the limitations on settlement releases was the Valakers versus ABM case. In that case, the plaintiff was a settlement class member in a prior overtime class action, didn't opt out, the case was dismissed. The plaintiff was bound by that release, but nevertheless brought a PAGA-only case alleging the same overtime claim plus some new claims. And I think that that's the important emphasis in Valakers is there were some new meal and rest break claims and other derivative claims that were not at issue in the prior case. And so the court in Valakers analyzed whether there was the effect of res judicata from the prior settlement on the subsequent litigation. Ultimately, the court decided that even though the meal and rest break claims and some of the other claims were not part of the prior case, that the plaintiff nevertheless was barred from pursuing the subsequent litigation. It's noteworthy that the court's rationale in Valakers, I think, was driven pretty heavily by California adopting the primary rights theory in terms of how they define causes of action. It's a pretty broad definition, which basically that a lawsuit that alleges a legal harm effectively includes all legal theories or different remedies available on that particular injury. So it's a little bit broader, and that was one of the drivers behind the Valakers decision. And so as a result of Valakers, it's very common that, particularly on the defense side, will want express language in the settlement agreement that the release has res judicata effect, and that the release oftentimes will state that it releases claims that are alleged expressly in the complaint and claims that could have been brought based on the operative facts in the complaint. I guess the question then becomes, well, how much broader do you get in terms of claims that are not expressly alleged? And that's where we get into what's referred to as the identical factual predicate doctrine. It's a very fancy term where the courts, basically look at, the scope of a release. And the courts will analyze the scope of a release in a variety of contexts. They can analyze it, and as we've discussed, whether a prior case bars subsequent litigation. But many cases are also doing an identical factual predicate analysis in the settlement approval contexts. And basically what the identical factual predicate doctrine means is that a settlement may preclude a party from bringing a related claim in the future, even if that claim was not presented and might not have been presentable in the class action, but only where the release claim is based on the identical factual predicate as that underlying the claims in the settlement class action. Let me switch slides. Now, the majority of the federal courts and the California state courts have adopted this doctrine, but it's a little hard to understand what the courts mean unless you get into the weeds of the cases. But basically, the majority of the courts define the identical factual predicate as a common nucleus of operative facts with the earlier class action. Same facts are, quote, at the core of both the unpleaded and pleaded claims. And what the courts mean by that is, had a judgment been based on an adjudication in the prior proceeding rather than a settlement, that the unpleaded claims would have been issue precluded because they turned on the same facts. The Ninth Circuit, however, has, obviously the Ninth Circuit, California always has to do something a little different. So there's like some nuances in the Ninth Circuit where one Ninth Circuit decision distinguished the identical factual predicate analysis from the same transaction test that's used for collateral estoppel purposes, explaining that a claim can arise out of the same transaction, but not necessarily involve the same underlying facts. And I do think that this nuance is important because particularly in the federal courts seem to be much stricter in how they analyze the scope of a release under the identical factual predicate doctrine. The state courts, because of I believe because of the primary rights theory, tend to find broader releases than the federal courts. So how close must the facts align? I think that the big takeaway from this is that there's no bright line rule, but I thought I would share some examples of some recent cases and how the courts in different procedural contexts applied the identical factual predicate analysis. And the reason why this discussion is important is, right, the parties want to make sure that the release that they ultimately can get approved by the court, holds up, and particularly from the employer side, that the release, that they're sort of getting what they paid for. So the first example is this decision in Shine versus Williams-Sonoma. In that case, there was an earlier class action, I think it was called Morales versus Williams-Sonoma, involved a bunch of different meal and rest break claims, unpaid overtime and minimum wage claims. And there was a later case that was filed, Shine, where a settlement class member from the first case brought a reporting time claim, same putative class, overlapping time frame. And the court concluded that because reporting time pay is a form of wages, a claim for reporting time pay could have been raised in the prior settled lawsuit and therefore was precluded in the Shine case. The court definitely, the analysis was rooted in the Valakers decision. And they reasoned that the fact that no claim for reporting time pay was alleged in the Morales case doesn't alter the determination that the same primary right, i.e. the seeking payment for unpaid wages, was involved in both cases. Another decision, the Amaro versus Anaheim Arena Management LLC case, that was in a different procedural context, in that it was a direct challenge to the scope of the release during the approval process. There were several pending overlapping class actions that were at issue. And the court held in that case that the language that was used in the proposed release was far too broad. And in that case, the release was framed basically to say that it released claims alleged in the complaint, but also any claim that, quote, in any way related to the allegations in the complaint. So in the court basically says, that could extend, they gave an example in that case that it could conceivably extend to a retaliation, like a retaliation case by a plaintiff who complained about meal and rest break violations. And that obviously was not contemplated. That wasn't based on the factual predicate in the class action complaint. So I think the big takeaway from that is, using language where you try to get the claims released, and any claims that are related in any way to the complaint, that would be a no-no. Another recent case that came out this year, actually, Torado versus Victoria's Secret. This was a case where the employer moved for a judgment on the pleadings to bar a class action based on a prior settlement. The first, and this is an interesting case because it deals with off the clock, and definitely an area of the law where you really want to be intentional on the scope of your release. But in that case, the first class action that was settled involved just general pre-shift off the clock work. And then the second case came and had very specific allegations of unpaid wages for mandatory pre-shift COVID-19 screenings. And the court basically said, even though the release in the prior case didn't specifically reference COVID temperature checks, that the court said that it met the requirements for the identical factual predicate doctrine. So those are just a few. There was a couple of other ones that I written an article about this recently on the preclusive effect of class releases. And there's a lot out there. As I said, there's no bright line rule, but I even found a case, I believe it was Chavez versus PVH Corp. Interesting case in my 20 plus years of litigating class and PAGA litigation. I think most lawyers on both sides would agree that when you get a release under Labor Code Section 203 for waiting time penalties or 226 for wage derivative claims, that those would encompass any factual predicate. Like once you have a class action that releases 203, you're sort of good to go. Well, this case, actually, they denied final approval after the parties had confirmed that their intention was that the waiting time penalty extend not only to the very discrete payroll debit card claim in that case, but also all of the various claims that were in other pending class actions against the same employer for meal and rest and unpaid wages. And the court did not allow that. And so, again, the importance of understanding what your release is buying you. There was another one, for example, Nangle versus Penske Logistics. In that case, I think it was also at the approval stage where there were prior claims for unpaid vacation wages, and the court held that there was not an identical factual predicate for purposes of a current unpaid wage claim. So again, no bright line rule on this.
Allison, I think we have a question.
Oh, sure.
Any dispute arising out of or in connection with. Do you see that by Chia Wang?
Let me see. The question is there a concern by only using the language, any dispute arising out of or in connection with any disputes or claims arising? I guess one could argue that this is maybe similar in any way, which is what the court took issue with in the Amaro. I think also it will matter whether you're in federal or state court. But I would say that could potentially, I think your safest bet, it seems to be, right? If you say that it's limited to the operative pleading or claims that could have been based on the same operative facts in the complaint. So that one's an interesting one. I think that there could be some risk in that one.
There's another one too about amending the complaint.
Yes, we are going to get to amending the complaint. And then if I didn't answer your question, I'm happy to do it. So some practical tips for drafting release language. As a mediator, I don't like to get involved in drafting any of your settlement documents, but I do think that it does come into play at the mediations. And so obviously you want to avoid overbroad release language, like we discussed the Amaro case, that it really should be limited to the operative pleadings and claims that are based on the facts in the complaint. And be intentional when you're releasing claims under labor code statutes that can encompass a variety of factual predicates. I mean, the three that came to my mind immediately were expense reimbursement cases, wage statement cases, and then the sort of like kitchen sink unpaid wage claims. There were two decisions, I think they were federal court decisions recently, that denied approval in a 2802 expense reimbursement case because the release purported to extend types of expenses that were not alleged, right? And so obviously the employer wants to get everything under the sun released under 2802. And at least in two courts, they said no. Like if it's a uniform case, you're releasing 2802 based on uniforms. That doesn't extend to mileage or cell phone. And so being intentional in what you're, what you're trying to, if you want the broadest release under 2802, you need to craft language that makes it clear that it does involve any and all expense reimbursements. And you may get that approved, you may not. And then obviously with unpaid off the clock, there's just so many different theories of off the clock. And so I think it will be important to make it clear how broad can you go? Or, or are you really limiting it to a certain off the clock theory? Maybe the employer, for financial reasons is paying a smaller amount, taking a bigger discount but in exchange that they've agreed to just limit it to a certain specific type of off the clock theory of liability. And so it's just the takeaway is to really be mindful of what's in the language in your releases. And then this is where we were going to talk a little bit about the amended pleading, and I welcome Justin's thoughts on this too. So post-mediation considerations, right? So you've reached a deal, maybe you've accepted a mediator's proposal, or you have, some agreement in principle, a term sheet, and things to keep in mind when you're doing a more formal long-form settlement agreement. Oftentimes, if new claims arise, which happens more times than not in my experience as a mediator, you're going to have to amend the pleading. And my recommendation is to make that clear. I try to make that clear in my proposals. If the mediation is going to end by way of a proposal, that the parties are agreeing as part of the proposal that they will amend the complaint, and if necessary, send a PAGA notice or amend an existing PAGA notice to the LWDA to ensure that they're effectuating a full release of the claims. Other considerations, many of the courts, in the state courts in California now have settlement checklists. So it's a good idea when you're putting together your long form or even an MOU. If you're in LA Superior Court, you know what's required from the judges in CCW, and making sure that your MOU or maybe your long form agreement, follows. I think even some of the courts even have template agreements now. And so obviously keeping those in mind when you're trying to get that's going to help you get things approved a lot quicker. And then confirmatory discovery. Justin was talking about the CULAR obligations as part of, preparing for mediation. Sometimes, again, claims come up during the course of the day, and, the employer wants a release for a certain claim. Plaintiff side doesn't have all the information, but they don't want to stop the day. They want to keep going and hopefully reach a deal, subject to some kind of confirmatory discovery. It may be, let's say, the employer only gave a certain amount of data through a certain time period, so they want confirmatory discovery about work weeks, pay periods, through the class period or PAGA period end date. That's very common. Sometimes you may need shift data confirmed. So bearing in mind that sometimes confirmatory discovery is something that needs to take place after the mediation in order to get the case approved. I don't know if, Justin, you have any insights on that.
Yeah, amending the pleading or the PAGA letter is usually not a big ask for the plaintiffs. They're typically willing to do that. The only exception is where when an amendment can knock out a case that you weren't even thinking about at the mediation, or you didn't even know about. And most plaintiffs want to avoid that because we all work in the same ecosystem. We see each other often. So it's usually bad practice to amend the complaint to kill a case you didn't know about until after you settled the case. Most plaintiffs' attorneys want to avoid that, and it all goes back to having a discussion beforehand about the scope of the mediation, what claims are going to be released, and avoiding surprises.
So I see a couple of questions. Justin, we can take one. Let's see. The first one said, how do you handle situations where defendant says it has no money but refuses to share documents? So I would say, as a mediator, yeah, in my experience, plaintiff lawyers, don't just rest on a representation from the in-house counsel that they don't have the money to pay, right? I think that they definitely have to produce some documents. There's a variety of ways to do that in my experience. Obviously, as a mediator, I'm not an expert per se in, looking at profits and loss or, audited financials, right? But Justin obviously has an expert. I know some employers are very sensitive about turning over their data. I remember years ago, I had a situation where the client gave me the financial information, I drove it over to plaintiff's counsel's office. This is obviously way back in the day before we did everything via Zoom. And I sat in the room with the expert retained by the plaintiff, who looked at the documents, and then I took those documents back. So it just depends on, but I don't see how you get and how you meet your KULAR obligations as a plaintiff's counsel without looking at some documents. I don't know, Justin, your thoughts on that?
Yeah, I agree. I mean, if you're not willing to show documents, the thinking is you must be hiding something. So, again, the best practice is transparency. Be a straight shooter if you want to get a deal done.
Yeah, and then there's another question that I think sort of dovetails on that about how you would deal with Section 558.1 issues where a company is asserting inability to pay, 558.1 in terms of like whether individual officers or directors could be also held liable. I think, and Justin, welcome your thoughts on this. I think one depends on whether the individuals are named in the lawsuit. I think if they are, then and they could potentially be on the hook, they may need to demonstrate their inability to pay, just like the corporation would.
Yeah, I mean, when I was doing these cases, typically I didn't name the owner. So, 558.1, bringing that up is kind of like the nuclear option that you don't want to, you usually try to avoid because it's going to piss off the other side, being sued personally as opposed to just the company. But, you gotta deal with it. You gotta take the initiative on that. You gotta look at the assets before the mediation happens. If you have any inkling that there could be financial inability to pay issues, typically the owner is not going to, give that voluntarily, but there are ways to look at it. You could, do a property search. You can investigate the company and look up who owns the company and search if that person owns other companies. So that's one way to tackle it. Typically I did ask to see personal tax returns as well. If they brought that up, and sometimes they'd provide it, and typically when they did provide it, that person is broke, usually. uh, Also, in my experience, when that happens, you're talking about like a small business, family owned. The company, probably wants to keep it alive so their children can work there. So it's another pressure point to emphasize when you're faced with that situation, I think.
Okay, there's another question. Do you recommend that the settlement ever include a requirement that the plaintiff amend the complaint to include all the claims, or is this doctrine enough? So I would not rest on the doctrine, especially because the case law is sort of all over the place, and I think it depends, as I said, if you're in federal court or state court, who your judge is, and so I think it is important that if you have a new off the clock theory that's different from the off the clock theory that was raised in the complaint, and you want to make sure that theory, is part of the release, I would not rest on just, pre-shift off the clock work, right? I think that case, the Toronto case in the Eastern District, easily could have gone differently in the Northern District, for example. So I think you're best served to amend the complaint, as agreed to by the parties. I would think that the defendant in particular would want the complaint amended to make sure that the labor code sections are identified and there's no question about what's part of the release. Let's see. Okay. Another one. While not drafting releases for obvious reasons, do you manage the drafting of the releases? And if so, does this occur generally after the mediation or before it concludes on the day of the mediation? So this is a great question. I have definitely been involved the day of the mediation. If the parties are working on an MOU, for example, I will definitely participate in those discussions. I've done it where I'm in the same room with the two both sides, lawyers for both sides. and we hammer out just to make sure that we're all on the same page. I don't typically, I have never and probably would not want to get involved, for example, with the parties sending me a draft of the release after mediation and asking. I feel like that's getting out of my role as a mediator and getting back into my role as a lawyer. So I don't know, Justin, your thoughts on that.
I feel like the release is less of an issue now because of the model settlement agreement in LA Superior Court, and a lot of people just default to that. And prior to that, we each had our own settlement agreements that we preferred, and some were more specific than others. So, I wonder if that it's going to be a problem if people rely on the model settlement agreement in LA Superior Court, but it's not as like tight as the ones I've seen in the past where the attorneys have drafted it before. That could be an issue down the line, but um, you know, uh, typically, I didn't push back that hard on the release unless that they're trying to include a new claim that wasn't even in the complaint or part of the conversation during mediation. I get that employers want to have finality, especially with meal period claims off the clock, 2802. So my approach was more pragmatic, but not everyone is like that. And if you're dealing with someone who's more strict about that, better to have an upfront conversation about that, or else you're going to be bogged down during the whole mediation, just fighting over that. And that's not conducive towards settlement in my mind.
Yeah, I would agree. Another actually, before we go on to this other question, another point that I didn't have in the bullet for post mediation consideration is not just amending the complaint or PAGA letter to add a claim, but there will be times, and this often happens, where you have a plaintiff who worked for a temporary staffing agency. So you have a client employer and a temporary staffing agency involved in the class or PAGA case. Sometimes they worked for multiple staffing agencies, and none of them might be actually named in the complaint, but you learn during the course of either discovery or informal discovery for an early mediation that the plaintiff either worked for the entire period of time for a staffing company or a portion of the time. And so it's imperative that the parties are on the same page about whether and which additional defendants need to be added. I would not recommend just resting on language that it includes, the defendant and any of their joint employers, et cetera. And I would think the staffing agencies would want them to either be expressly named or and added as a defendant. So there's not just considerations for amending the pleadings for claims or causes of action, but also parties. Okay, what was we missed one. How often do alter ego piercing the veil issues become primary issues in the mediation? At collectability.
I think you probably need to litigate that issue. If the employer is bringing up alter ego or piercing the corporate veil, then they typically, want to limit the class. So it's an issue that you have to get in front of before the mediation, or else, the scope of the class is not going to be to your liking on the plaintiff's side. So when I've been put in that situation, typically I had to beat a motion to dismiss in order to, get those other entities involved. You have to do that in order, for the parties to get serious about encompassing all corporate entities. So usually there is litigation involved. But on the other hand, you could have like an employer who's like very flexible and just wants to get the biggest release possible. But in my experience, they typically want a discount if there are like some serious alter ego issues and piercing corporate veil. So it's probably something that you should litigate or hammer home before the mediation starts that, hey, look, I got some great ways to pierce corporate veil or argue joint employer or whatever. You got to include everything for this mediation to be successful.
Okay, let's see. What do you recommend defense counsel do when plaintiff's counsel refuses to share data supporting the claims, but merely gives summary of pay periods, percent of violations, etc.? I hope I understand this question correctly, and if I don't, happy to chat offline about this. I usually see the issue more when the defendants are not giving the plaintiffs the data that they need. But I mean, so if you both have data, like you have an exchange of data, I think that there should be, I want to make sure, given summary of pay periods, I would think that the defendant would know the pay periods based on their own analysis because they have access to that information. If your question is, how did the plaintiffs arrive at their figures? I think that is absolutely a valid question that needs to be, like, for example, if you guys have a different work week count or a different pay period count, you definitely need to, again, I encourage talking both sides, even before the mediation, at the mediation. As a mediator, I often will get the lawyers in a room to hammer it out, because it is not uncommon, for example, where the defendant gives a sampling of time and date payroll data, and maybe they give 10%, right, to the plaintiff. So the plaintiff hires an expert, they analyze 10%. The client, that the employer, however, looks at 100%, right? So they're, just by virtue of the plaintiff having to extrapolate, right, they're going to have different work week, pay period, violation rate numbers. Sometimes that can be clarified through, as a mediator, I often will see both sides' numbers. And so I can get information, and of course, with approval, to share that with the other side, get an understanding of where's the disconnect. Sometimes the disconnect in terms of violation rates is rooted in the parties' respective theories of liability. A very, very common one, for example, is in meal break cases. The employer will often analyze the data excluding meals that start at 5.0 as violations, where the plaintiff side will deem those violations. And so you will see violation rates that are drastically different, right? You'll see one side shows 15% violation rate and the other side shows 55% violation rate. And you start to figure out during the course of the day that that's because of how they're defining what constitutes a meal break violation. And so, so I hope I answer your question. One, you definitely have to make sure that both sides have the information they need to analyze data. And if you have a difference in how the data was analyzed or the results, again, I think you're going to need to have that understanding. And if you need to use the mediator to help, I'm always happy to get involved in making sure everybody's on the same page.
Yeah, usually you're not going to have issues working off the same data set, but usually the issues evolve from, different interpretations of what's in a violation. Like Allison brought up that meal period example where plaintiff's attorneys push for, 5 hours being a violation, whereas, defense does 459, that's common. I've also seen issues where plaintiffs' attorneys had a different way of calculating the regular rate of pay, that causing a problem. So, you really have to drill that down and what's causing the discrepancy and talk about it in order to have a effective negotiation. And, sometimes plaintiffs' attorneys, they only analyze a fraction of the sample as opposed to the whole sample that they were provided. So that's another good thing to flag if you're a defense, if they're, doing that. So that's another reason why the numbers could be different.
And there's actually a question, Justin, on that. There's two more questions. One of them is about sampling and what percentage of sampling do you see that the courts don't feel is sufficient? I'll answer from my viewpoint, and Justin, I welcome your thoughts too. I mean, I'm by no means an expert. I can't necessarily state what's statistically significant, but in my experience, the larger the class, 1,000 plus, you can get away with a smaller sampling, right? You can get, if you have a 5,000 member class, giving a 10% sampling oftentimes is considered statistically significant. If you have a 100-person class, again, I'm not a damages expert, but you may have a tougher time with only a 10% sampling. Like you may need a 50% sampling, or and some judges are more finicky about than others. I don't know, Justin, in your experience when you were.
Yeah, I agree with that. Generally the bigger the population, the smaller the sample you need to get a representative sample. And what I've done when confronted with this issue is give the judge a number as far as the margin of error for the sample we use, and usually that's enough. Usually the error rate is small in the cases I've worked on.
Okay, the last question. How do you, there's two more questions. I'm happy to stay longer too, by the way. How do you approach mediations for cases in which there are interveners and or related or consolidated cases? Do you invite everybody to the mediation and attempt to reach a global? Do you exclude them? So this is a challenging area to answer the question. I would say my role as a mediator is not to get involved in that. My recommendations is I always think global mediations make the most sense. And I do think that there should be full transparency, and even the procedural rules in the courts, both federal and state court, have requirements in terms of, notices of related cases in state court, notice of pendency of actions in federal court, that, make sure that everybody's on the same page about what's out there in terms of the pending cases. So this gets really nuanced, and there may be reasons why or not to invite people. So generally as a mediator, I stay out of that. And let counsel decide, which makes most sense. But obviously, like, global peace for everybody is the way to go. And then there's one more. Okay. Apologies in advance for the basic question. New to this field. Welcome to this field. What if you have a frivolous suit that was settled before extensive litigation and even before reaching mediation, but the complaint was broad and ambiguous, obviously including causes of action under PAGA? What are best practices for negotiating that type of release? Justin, what are your? I need to review this fact pattern a little closer. Okay. I guess my first question is, like, why was the first why was the original suit that was settled frivolous? And I guess we might have to take this offline because I might need a little bit more information, but I would need to have an understanding of, like, whether the prior suit was settled on a class or a PAGA basis. What was the, I'm not sure I can answer this question without more information.
Well, if you settle the case just on an individual basis, the PAGA could still survive, but the class won't. So if you want to, get rid of the PAGA, you probably have to devote some money towards a PAGA release. And you got to involve the LWDA as well, because those have to be approved, right? Or disclosed.
Yeah. So if it was a class or PAGA, and if it was truly frivolous or there were problems with that, I would think that the court wouldn't approve it. But if it was, approved for some reason, yeah. Why don't you email me and Justin, and we can address
Okay.
that one. I don't want to misinterpret the oh, I think are we done?
All right.
Yeah,
Allison and
last
Justin, thank you.
questions, and
Oh, last question?
feel free to email us questions. We're willing to help out. And
Allison and Justin, thank you both so much for your time today. We appreciate you speaking on this topic, and I hope our members enjoy the rest of their afternoon. Thank you.
Thank you.
Thank you.